Everybody for coming in today. We have Beverly Allen and Adam Birnbaum. Adam is a longstanding Pierce County attorney. He practices primarily with landlord-tenant. He has also practiced for 30 years. He works within Pierce, King, Thurston, and Kitsap counties. Beverly is a local Tacoma attorney. She has many years of experience. She's also volunteered for and advised the members of the Tacoma for All Steering Committee that helped pass Initiative 1, Tacoma's Landlord Fairness Code, which is why we're all here today. So she will be speaking about that, and Adam will be discussing the landlord's perspective. So, Beverly, please take it away.
Should I unmute? Or
yeah, you should unmute.
Hi, everyone. Hold on. Can everyone on Zoom hear me? Oh, I'm echoing still. Okay. Okay. Do we need to turn off my lapel? Or? Oh, okay. So if there are any problems with sound, please put that in the chat, I suppose, or raise your hand. So welcome. Those of you who are live and those of you who are on Zoom, Beverly Allen, I wouldn't say many years, but 14. I guess that's coming up on it, a little less than half. Yes, Adam and I both agreed to help the law library today with this presentation because, of course, on December 8th, something big happened with landlord-tenant rights in the city of Tacoma, rights and obligations, I should say, and that was the Landlord Fairness Code. So since then, we've had a few changes in terms of how writs are issued. We are coming up at the end of the winter eviction moratorium, still in the school year eviction moratorium, and there are, of course, other requirements. Adam, did you want to add anything to?
No, I think that's a good lead in. I'm looking forward to sharing some of those changes as part of this presentation.
Yes. Okay. Okay. All right. So first, we're going to talk about, these are our learning objectives here. So the history and overview of the Landlord Fairness Code, I do think it's helpful to talk a little bit about how this came to be and something of the coalition, the drafting, the intent. The prohibited cold weather and school year evictions, those are some of the most, I think, sweeping or impactful changes, I would say, to the Tacoma Housing Code that was in place, at least as far as July. July was one event where the city council passed some new tenant protections. They didn't go quite as far as the Tacoma for All committee wanted them to. So the initiative process moved forward, went to the voters. And as I said, the cold weather and the school year evictions were pieces that the city council did not agree with, but that were pushed forward in this initiative process. We're going to talk about motions to vacate and stays of writs of restitution. Also, we're going to talk about the city code obligations and what non-compliance with that might mean for landlords. Dzaman versus Gowman, which is one of my favorite cases. It's a very pro-tenant case. And so I'm sure Mr. Birnbaum and I have different takes on that particular case and how you can use it. And then we'll be talking about damages and attorney fees. And now I think I know how to. So just curious, Adam, if you have anything to add to sort of the political pieces of it. I do know that there were obviously some email listservs, some chatter.
There was a lot of chatter going on when the initiative was kind of working its way through the system. And of course, I think a lot of the landlord stakeholders were surprised with how quickly all of the aspects that did get passed through actually made it through and got uh, voted on the ballot. So it was one of those situations, I think, that there was a lot of noise from the landlord side as these issues were pushing their way through. But there came a point where it became apparent that these were going to be issues that we're going to have to deal with in the context of eviction actions. And I think at that point in time, it just became a matter of how we're going to deal with negotiating around these new rights that were given to the citizens of Tacoma.
Out of curiosity, was anybody here following the court case about this, the decision issued by Judge Ashcraft? No?
A little bit.
A little bit, okay. It also made the news. So Tacoma for All versus City of Tacoma, this is a real court case, that was litigated right here in Pierce County. This litigation came about because the city had actually both passed the ordinance and then also put it up as a competing ballot initiative. And that question about whether the city had the ability to do that, first of all, and whether or not that was a fair decision for the voters was this is kind of the second part of that question. And what Judge Ashcraft decided is that there is a provision in the city charter that allows the city to put forth any referendum to the voters. And so he cited to authority, any is a broad word, and said, yes, the city can put competing ballot initiatives on there. But what got the city's ordinance off the ballot and probably allowed this to pass was that the city also did not inform voters that it was already law. So essentially, if you read the decision, Judge Ashcraft speculated that people might be voting for the city's initiative because they didn't understand that not voting for the city's initiative would have no effect, essentially, and that would also take away votes potentially from the broader citizen initiative. So that was the first fight, and that resulted in just one initiative going forward, the citizen initiative. There may be future fights. I would expect it, unless and until the charter is changed, which only happens once every 10 years. We're actually in the middle of a charter review process. I would expect further citizen initiatives to face competing ballot initiatives on this topic. But it was passed, and the effective date was December 8th. And on that day, all hell broke loose. Okay, next slide. Okay. So Adam, do you want to talk about this slide?
Yeah, so as part of the code, there are certain provisions that are put into place with regard to evictions, certain prohibitions regarding on when and how evictions can take place, limitations regarding excessive fees, and we'll go into these in a little bit more detail a bit later on in the presentation, regarding discrimination, and then some specific rules regarding rent increases as far as timeliness and the range of amounts on how that can be implemented by the landlords.
And I think it's worth noting, and this isn't in the slide, but it is worth noting that the July ordinance from the city, which is TMC 1.95, I think. Let me
Yeah, that's
double check
correct.
that. 1.95?
Yeah, it is 1.95.
Great. It's still in effect. And the interesting part about that is the city itself is enforcing its ordinance and not enforcing the Landlord Fairness Code. So the Landlord Fairness Code is a litigant-driven, tenant and landlord-driven process without, at this moment, enforcement from the city. They are taking complaints, and I'm assuming studying it, but other than that, no action. All right, next slide. Okay, so what's not allowed? All right, next slide. All right, I'll talk about this one and then we can just switch up.
Sure, yeah.
So prohibited evictions, one type of eviction, and this is the moratorium, is that students, teachers, school staff, and their families can't be evicted during the school year. And that includes anyone who's got legal custody of a child. It also includes step parents. It also includes guardians. So for the family law folks, that's minor guardians. Foster parents, custodians, or an educator. Now, here's where you would want to look at the definition section pretty hard, because there are some misconceptions out there right now. Students is K-12, unless the education portion of that extends beyond the 12th grade. But staff and educators, that's a hugely broad definition. That includes janitorial servers. That includes the school lunch staff, right? That's a broad category. And Adam, do you
Yeah,
wanna chime in?
and as Beverly says, it's very important that you review the definitions contained within the code when dealing with these sections. For this particular code section, it's 1.100.090. And if you look at the definition of educator, it's very, very broad. You know, when we think of educator, you think of the staff, teaching staff, and administration staff that you typically see in a school. I'll give you a couple of additional examples. Provides this is in addition to teaching staff, social workers, psychologists, school nurses, speech pathologists, custodians, cafeteria workers, and maintenance workers. So it's very important from the landlord perspective that when you're starting an eviction action, that as part of your inquiry with your client, with your landlord, you have to have them look at their application and see in what capacity they're employed, because they may be employed as a janitor or some type of maintenance worker. And if they're working for a school, then this particular prohibition would apply. I'm not sure if Beverly was going to go into this, but also one of the definitions you have to look at is school. You know, we think of school as basically, you know, K through 12, but the definition also incorporates childcare, early childhood education, and assistance programs. So you may have someone who you would think of as a minor that's preschool age, but if they're in a child care, then that family would potentially have a defense and be entitled to the school year prohibition. So again, please look closely at the definitions as we go through these, as we go through the code initiatives. It's very critical. A lot of the definitions are much more expansive than you would expect them to be.
I will say that how I see this on the show cause docket right now is the commissioners are asking the property managers, have you seen a kid? Have you seen a child in the units? Do you have any knowledge that there's a child? I don't think they're going so far necessarily as to say, is anyone working for a school? But that question I have heard asked many times on the show cause docket. And so at the very least, it should scoop up families with children. The rest of it, though, in my view, that's going to be up to the tenant to bring to the court's attention, because I don't think the courts, landlords and property managers aren't keeping track necessarily of people's changes in employment or so on and so forth. So that will be one that the tenant will have to really plead
Yeah.
and have some support for.
Yeah, absolutely. I think as a practical matter that would be an affirmative defense because, as Beverly stated, the court's inquiry is only going as far as are there any children of school age in the household, and that's as far as they're going, as far as their inquiry on the record.
Yeah. Next slide.